A number of guests duly introduced by fellows beg leave to attend your meeting. Is it your pleasure that I welcome them in your name? Thank you. Minutes.
Ordinary meeting, Thursday the 13th of November 2025, Burlington House and online. Professor Martin Millett, President, in the chair. The minutes of the ordinary meeting of Thursday the 6th of November 2025 were read and signed. The Honorary Secretary read the names of candidates for ordinary fellowship who were on the ballot closing on Thursday the 27th of November. The following communication was then laid before the Society. The Melsonby Hoard, Vehicles and Power in the Late Iron Age, North Yorkshire, by Dr. Sophia Adams, FSA, and Professor Tom Moore, FSA. Thanks were returned for this communication. The President announced that the next meeting would be on Thursday the 20th of November and then adjourned the meeting. A reception followed.
Is it your pleasure that I sign these minutes as a true and complete record? Thank you. We now come to the main business of the evening, which is to hear a lecture by Professor Louise Wilkinson, FSA, the 1225 Magna Carta, a more compassionate society. But first, Michelle Johnson is going to speak about the Magna Carta project. By night, Dr. Michelle Johnson is a historian specializing in the biographical aspect of public library history in the long 19th century. She's a fellow of the Royal Historical Society, an associate fellow of the Institute of Historical Research, and a long-time trustee of the Mass Observation Archive at the University of Sussex. By day, Michelle is Learning and Outreach Manager at the Society of Antiquaries, with responsibility for opening up the building and collections to new audiences through open days, late events, school workshops, and a volunteer program. She currently manages the Magna Carta 1225 project for the Society. Thank you.
Good evening, everybody. Don't worry, I'm not going to talk for long. The main attraction is to come, but I just wanted to say a few words before we begin, because this evening's lecture is as part of a wider project taking place at the Society called Magna Carta 1225. And as most of you will know, this room was completely transformed during the summer for our Magna Carta 1225 exhibition. You can see an image there on the screen of how the room looked, with the trees in the middle of the room and the room green-lit to resemble an enchanted forest, which was because of the Charter of the Forest, and we did have a copy of the Charter of the Forest on display as part of this exhibition. So the exhibition was generously supported by grants from the National Lottery Heritage Fund, Farrer & Co., the Edward Harvest Trust, and the Magna Carta Trust, the Worshipful Company of Art Scholars, Artscapades, and an exciting anonymous donor. The exhibition was really very well received. We were so happy with it. We had 5,500 visitors from all over the world across the summer, and it was uniformly positive feedback, or almost uniformly positive feedback. And the feedback was invited on small paper leaves to, again, lean into that forest theme that were dropped into our ballot boxes across the summer. And I've transcribed just a few of them here for you to get a sense of how people responded to the exhibition. And what you can also see from these names here is that people came from, as I say, all over the world. So from Mexico, wow, thank you. I love the tie-in to modern day understandings, cool and beautiful illuminated manuscripts. Very surprising, did not know you were here. And that was just wonderful because that was exactly what we wanted to achieve with the exhibition, was to bring new audiences in. And we also had a couple of quite comical submissions as well. I particularly liked this one. Just fantastic. And we believe the sister responded. There was another similar leaf in the box about the sister's response. So this is a whole novel waiting to happen all by itself. But for the most part, it was sensible feedback that helped us to see what people responded to positively across the course of the exhibition. And if I take you on to our next slide, you'll see here at the very front, you can see a table covered in green leaves. And those are the leaves that had the exhibition feedback on them. But the project didn't end with the ending of the exhibition run in September, even though people may assume that it did. We were especially keen to keep our enthusiastic team of volunteers involved and engaged. Between them, they contributed over 1,000 hours of their time to providing front of house support during the exhibition, and the exhibition simply couldn't have taken place without their contributions. Here we see some of the volunteer team at the wrap party in September, raising a glass of champagne from bottles that were kindly donated by our neighbours at Fortnum and Mason on Piccadilly. Exactly, it's worth being part of our volunteer team, I should say that. Definitely true. So the way that we're continuing the project now is in two different ways. We've got the Magna Carta 1225 online exhibition that's currently being co-curated by around 12 volunteers, some of whom developed spotlight talks during the exhibition run, which was an unexpected bonus outcome from the exhibition. Our volunteers got so enthused by the topic, they started doing independent research and ended up doing these spotlight talks during the exhibition run, which really added a lot of depth and richness to visitors' experience of the exhibition. The online exhibition will go live early in 2026, so keep an eye on the website for details. And if there are any fellows or expert medievalists in the room who'd be happy to offer their time to review the exhibition content before it goes live, and that would be January, February time, do please drop me an email and let me know. My contact details will be at the end of the slides. The other way that we're continuing the project is through our school's workshops. We've developed and piloted a completely new workshop called Magna Carta and the Making of History, and this is aimed at key stages 3 to 5, so that's secondary school students. These are free 90-minute workshops that use a range of sources from our collections to help young people discover the impact of the Charter across an expanded time frame, whilst also reflecting on the impact of archives, libraries and museums like our own on the making of history. So do spread the word to your teacher friends. These are free to book and we're taking bookings now. And you can see there a recent school group from the University of Birmingham, sixth form school, in fact, they've come along and they've studied the subject through our collections. Another way that we are continuing to work with the project or on the project is through our creative and diverse responses to the exhibition themes. So we've got 2 makers in residence at the moment, Sahela Baluch and Tamsin Loxley. You can see them there on the right, my right, I think your left. And we also had a late event in September, which was co-curated by a team of young people. You can see them there on the left, right, on your right. And then tomorrow, if anyone finds themselves in the area, we are being taken over by a group of sixth formers from a school in Kilburn. They've been developing a number of different talks and performances, all related to the Charter of the Forest. So there's going to be a kind of woody forest theme to the day, and you're all welcome to join us from 11 o'clock tomorrow. It's entirely free and drop-in, and it's going to be a lot of fun and very important for young people to get insight into what it's like to work in a cultural heritage organisation, which is what they have been doing through a number of training workshops we deliver with them in the last couple of weeks. So that is all I wanted to say. I just wanted to have an opportunity to highlight the value of the Magna Carta 1225 project that we have been running, to let people know that the project is ongoing, and also to kind of introduce Louise's talk today and how delighted we are to have a real expert in the room to talk to us on the subject tonight. And this photograph here is from the late event that was co-curated by a team of young people who all live in the London area. And we did have a couple of nights here battling it out in the courtyard, and you can see them at the centre of the photograph. So thank you everybody for listening to me. The learning@sal.org.uk is the address if anyone wants to get in touch about school workshops or to find out more about the online exhibition. Thank you very much.
Thank you very much, Michelle, and thank you for your sterling work in this Magna Carta project. Now, it gives me great pleasure to introduce Professor Louise Wilkinson. She's Professor of Medieval Studies at the University of Lincoln. Her research focuses on women, politics, and aristocratic culture in late medieval England. She was a co-investigator of the Magna Carta project in 2012 to 2015, and before that of Between Magna Carta and the Parliamentary State, the Fine Rolls of King Henry III, 1216 to 72. Professor Wilkinson has widely published on medieval women and 13th century life. Her next book, Women, Lordship and Power, the English Aristocracy from 1199 to 1327, is contracted to Routledge's Medieval Worlds series. She is a trustee of the Lincoln Record Society and the Historic Lincoln Trust, and joint series editor of Routledge's Lives of Royal Women book series. Thank you, Louise.
Thank you, and good evening, everyone. I shall move on to my first slide. There we go. So, February 2025 marked the 800th anniversary of the 1225 reissue of Magna Carta, often described as the definitive Magna Carta, because its contents underwent no significant revisions after this date. And indeed, 3 of its clauses remain on our statute books today. The clause setting out that the English Church shall be free and have its rights undiminished and its liberties unimpaired. The clause stating that the City of London shall have its ancient liberties and free customs. And another clause which stated, rather helpfully, that no freeman shall in future be arrested, imprisoned, or dispossessed, or outlawed, or exiled, or in any way ruined, except by the lawful judgment of the peers or by the law of the land. And to no one will we sell, to no one will we deny or delay right or justice. Now, 10 years ago, I was very fortunate in that I was one of a group of scholars who worked on the Magna Carta project, funded by the Arts and Humanities Research Council of the UK. This project was led by Professor Nicholas Vincent and focused primarily on the 1215 Magna Carta to mark its 800th anniversary. The project looked in depth at the grievances and broader issues that had emerged in the reigns of King John and his predecessors in response to the financial and other pressures of Angevin government. And it also culminated in a major exhibition at the British Library and a whole series of spin-off exhibitions in places like Kent. And I was in charge of the production of the school's resources as then a relatively youngish mother. Now, some of the key findings of this project were a greater understanding of the physical production of the 4 engrossments of the 1215 Magna Carta and an enhanced appreciation of Magna Carta as something more than a reflection of male baronial interests. It was, after all, addressed to all free people, men and women, and in its finer detail dealt with the needs of a broader cross-section of society than had previously been acknowledged. As a historian of women and children, these research findings spoke especially to my own interests. Of course, the 1215 Magna Carta was only part of the story. It was valid for only a matter of weeks after Pope Innocent III famously absolved King John from observing its terms. Magna Carta was reissued by the royal government during the minority of King Henry III, John's son, who was just 9 years old at the time when he succeeded to the English throne after John's death, amidst a bitter civil war. The civil war was fought between royalists and rebels. The rebels sought redress against the most oppressive elements of royal government. And here it's worth noting that Henry III's reign was the first reign in England since the conquest to witness a child on the throne and the king's younger siblings placed in guardianship until their majorities or marriages. King Henry III, who's shown here on this slide looking all youthful, was crowned at Gloucester on the 28th of October 1216 by the papal legate Guala, in the presence of the soon-to-be regent William Marshall. Less than a month later, Magna Carta was reissued by the minority government, the most loyal supporters of the young boy king in an amended form in the hope of encouraging peace. This version of Magna Carta was, however, carefully crafted by the new government to remove the clauses most damaging to the new king and his government. Removed were measures such as those that allowed the English church free elections. After all, no one wanted a hostile bishop. And in addition to this, other clauses were removed that insisted on the removal of King John's unpopular associates or that potentially hampered the royalist war effort in any way. Gone too was the infamous security clause, featuring 25 barons who had been empowered to enforce Magna Carta if the king breached its terms. For our purposes, it is worth noting that this new version added a new provision that a widow was not to be allowed residence rights in her dead husband's main dwelling if it was a castle, but was to be provided with an alternative residence instead. Although the 1216 reissue of Magna Carta did not lead to significant new gains in the royalist war effort, the liberties and customs enshrined within it retained political currency during the peace negotiations that concluded hostilities during the course of 1217. Magna Carta was reissued for its second time in November 1217, now with 47 clauses compared with its original 63, and was accompanied by another charter, the Forest Charter, hence the later emergence of the name Magna Carta to distinguish the two. Magna Carta and the liberties enshrined within it retained currency in the years that followed. Stephen Langton, a Lincolnshire man, Archbishop of Canterbury, and Hubert Walter, the King's Royal Justiciar, were vocal advocates of the Charter. And on the 11th of February 1225, Magna Carta was reissued yet again, this time with 37 clauses, largely based on the 1217 text, with certain provisions amalgamated together. Why 1225? Well, it was reissued against the backdrop of a French invasion of Poitou, which threatened King Henry III's territory, Gascony, and necessitated a costly military campaign led by the king's younger brother, Richard, Earl of Cornwall, and William Longspay, Earl of Salisbury. To finance it, a tax, a 15th on movables, was approved by a royal council in London in return for the reissue of Magna Carta and the Charter of the Forest. The 1225 Magna Carta was the first reissue to be issued under Henry III's Great Seal. It was also the first reissue to have been granted freely by the king and claimed to have been granted to all of his men, as you can see on this slide. Significantly, the 1225 Magna Carta preserves several important clauses that directly and explicitly protected the rights of children, women, and their families. And it's these clauses that will form the main focus for my talk this evening. First, however, we should note that Magna Carta was incredibly well publicised. It was sent out into the counties where sheriffs read and proclaimed its text. And we know of at least one great lady and one community of religious women who were instrumental in preserving an exemplar of the 1225 Magna Carta. The exemplar for Wiltshire was eventually placed in an Augustinian nunnery for safekeeping, Laycock Abbey in Wiltshire, which had been founded by this lady, Ella, the widow of William Longspay, Earl of Salisbury and Sheriff of Wiltshire. William had died in 1226 and had witnessed the 1225 reissue of Magna Carta. Ella was, in her own right, Countess of Salisbury and heiress of the barony of Chitton in Wiltshire. She was also, unusually for a woman, appointed as Sheriff of Wiltshire and served in that capacity in 1227 to 28 and 1231 to 1237. A deeply pious woman, she founded Laycock Abbey in 1229 and joined that community herself in 1238, becoming a nun and then its abbess. An endorsement in a 13th century hand on the back of Laycock's Magna Carta, which is now in the collections of the British Library, reads, "From the deposit of the Knights of Wiltshire." And it makes perfect sense for this exemplar to have been transferred to Laycock in Ella's time. Ella's personal influence, or at least her local renown, explains perhaps why it was not deposited instead at Salisbury Cathedral, as other royal charters had been in the past. Furthermore, as a widow and a mother of at least 9 children, good for her, including some like Nicholas, her youngest son, who was still sufficiently youthful to be a minor in wardship in the 1230s, the clauses of the 1225 Magna Carta had something personally to offer Ella. So, what survived of the 1215 programme for women, children and families? The 1225 Magna Carta preserved some important clauses that protected the interests of women, children and their families. Notable clauses included Clause 2 on baronial reliefs, which set them at £100 and set knightly reliefs at 100 shillings. Clause 3, which stated that underage heirs were not to pay reliefs or inheritance taxes after wardship. Clauses 4 to 6 offered protection for underage heirs and their lands from disparaging or disadvantageous marriages and exploitation. And also, Clause 7 protected widows' property rights and offered widows protection against forced remarriage. Now, in order to understand why such measures were needed in Magna Carta, and indeed were needed in the first place, we should turn to consider attitudes towards women and children in this era. English society in the 13th century, in common with other societies in Western Europe, was profoundly patriarchal. Women were seen as the inferior sex. Canon law and English common law laid down that daughters should be subject to the authority of their fathers and wives to their husbands. Deep-seated concerns about the physical and psychological weakness of women, their lack of reason, their fickleness, their carnality as heiresses of the biblical figure Eve, rendered womankind vulnerable and untrustworthy, and therefore in need of male governance, guidance, and discipline. I can see a few rolling eyes there. Yet despite these prejudices, women enjoyed certain rights and privileges. Although they were usually regarded as second-best heirs, women routinely inherited lands held by military service and sergeantry as heiresses and co-heiresses when there were no male heirs in the same generation. According to my calculations, no fewer than 8 of the 22 earldoms which were in existence for all or at least part of the period from 1199 to 1327 passed to a female heir on at least one occasion or more. This was true for the earldoms of Devon, Essex, Gloucester, Leicester, Lincoln, Salisbury, Surrey and Warwick. In addition to this, the estates held by the Earls of Chester, Earls of Huntingdon, Earls of Pembroke and Earls of Winchester were dispersed among co-heiresses and their descendants after these men died without direct male heirs. According to Scott Waugh's calculations, 110 of the 192 baronies in existence between 1200 and 1327 descended to female heirs. But what of non-inheriting daughters? They had rights too. Contemporary legal treaties anticipated that they would usually be provided with marriage portions or dowries in the form of land. Most women of the property classes married and often served as their husbands' assistants and deputies in the management of households and estates or other assets. They were valued as mothers and were often closely associated in the early education and upbringing of their children. Provided they survived the dangers of medieval childbirth, women also tended to live longer than men, much as they do today. Comital and baronial wives, for example, usually outlived their first husbands, especially if they were themselves second wives and remarried. 58 English earls in the period 1199 to 1327, out of a possible 73 included in a survey I conducted, left widows, although at least 15 widows subsequently remarried. And if the picture is widened to encompass a broad range of baronies, then similar patterns emerge. In a sample of 81 English baronies for the period 1217 to 1327, Scott Waugh found that 233 husbands were outlived by their wives, although 94 of these women remarried. Widows' rights to dower a share of their dead husband's lands were well established in principle as well in this era, and as widows, women were able to control property and head households in their own right. Furthermore, although women seldom served as officials or staffed the juries of royal or local courts, they still occupied central places in families and sometimes served as employers and lords in rural and urban communities. There was also a profound sense in contemporary writings that women, as the weaker sex, ought to be protected and treated with affection and kindness by their husbands, by their male guardians, and their male kin. And we get a striking sense of a married woman's legal incapacity, but also of the way in which a wife still deserved consideration and kindness in this passage from a late 12th century legal treatise known as Glanville. This passage, as you can see, says that a woman of full capacity, so a woman who's unmarried, of full age, such as a widow, may make a testament. But if she is in the power of her husband, she may not, without her husband's authority, dispose of chattels which are her husband's, even in her last will. Yet it would be truly kind and credible in a husband were he to allow his wife a reasonable division. Many husbands, Glanville goes on to say, in fact do this, which is much to their credit. Isn't that nice? Let's hope it was true. So let's move on then to consider attitudes towards children. Childhood, like womanhood, was associated with the need for protection in early 13th century England. Childhood was seen as a life stage that was characterized by vulnerability, physical weakness, and incapacity, regardless of gender. We should also bear in mind that there were relatively high rates of infant mortality in this period. Childhood was, however, also recognized as a developmental stage characterized by feeding and growth, innocence and playfulness, and by the need for socialization and education to prepare children for adult life and responsibilities. Not altogether surprisingly, there was a strong social expectation that parents, especially fathers, like this one in this image who's pointing at his wife and children, should be heads of families and should be responsible for maintaining and caring for their children. Furthermore, children whose parents died possessed rights. A man surviving children, for example, had rights to a specific share of his goods on his death, like his widow, a third. Common law also recognized children as heirs to lands. But children were also regarded as legally incapable of holding and managing estates while they were minors. Entries in the Curia Regis rolls, for example, show how the common law usually operated to prevent children from suing or being sued before the royal justices until they came of legal age. English law and custom recognized that children who lost their fathers especially needed to be cared for and their property safeguarded. It was in these cases that wardship kicked in, and by 1200 the rules for wardship usually operated in such a way that the lord kept the child's land, if it was held by military service, and assumed responsibility for their person until the child came of age, 21 for men and 16 or marriage for women. The problem was that rights of wardship over children and over arranging their future marriages might be given away or sold to third parties, who might be unscrupulous and exploit or asset strip the ward's properties. Anxieties about unscrupulous and predatory guardians permeated contemporary Romance literature. In the Lay d'Avaloc, written between around 1190 and 1220, we encounter Argenteuil, an heiress whose guardianship was entrusted to her uncle, who swore loyally to raise and keep her land for her until she was of an age to be married. Unfortunately for her, though, her guardian contrived to marry her off to a kitchen boy so that he might keep her lands for himself. Of course, in this case, we're dealing with a nice story. Everything turned out well in the end, since the kitchen boy, Havelock, turned out to be the son of the King of Denmark and was ultimately able to recover his own and Argenteuil's inheritances. Isn't that convenient? If only life were like that. Now, moving on then, if the need to protect widows and children as vulnerable members of society was something enshrined in English common law and custom, it also spoke to wider trends which encouraged people to feel compassion and to perform charity towards those less fortunate than themselves. Furthermore, the political situation in England in the aftermath of the First Barons' War of 1215 to 1217, and during the early years of Henry III's reign, brought the vulnerability of women and children as victims of war and as victims of the displacement and changes in fortune that could follow in its wake into sharper focus, creating a receptive environment for the preservation of their property rights. The general air of 1218 to 19, when the royal justices travelled around the country during the first fragile years of peace, undoubtedly shone a spotlight on the levels of distrust between royalists and former rebels, and the difficulties that rebel widows and their children faced. Take, for example, the experiences of this lady, Margaret, widow of the great northern baron and rebel Eustace de Vesey. Now, unfortunately for Margaret, Eustace had been fatally wounded by an arrow during the siege of Barnard Castle in August 1216. On his death, Eustace left behind Margaret as his widow. She was the half-sister of Alexander, King of Scots, and he also left behind a young son by the name of William. Although in the months after peace was agreed in September 1217, the fledgling government of King Henry III recognised William as Eustace's heir and Margaret's rights to enjoy her dower as his widow, it initially awarded keeping of young William's barony of Alnwick to Richard Marsh, Bishop of Durham, the English royal chancellor. Then, in early 1218, the royal government awarded custody of both William and his estates to the Earl of Salisbury, another staunch royalist. When Margaret, William's mother, refused to hand over the person of her son, the Earl of Salisbury's steward seized her dower and her goods. Left in straitened circumstances, Margaret appeared before the royal justices at York, whose clerks recorded her situation and promised to produce her son in February 1219. Only then were her dower and goods to be restored to her. Something of the vulnerability of other widows and their children further down the social scale is suggested by another case, this time from 1217. This case comes from the Fine Rolls, and it records how a local landholder in Shropshire, Alice, the widow of Richard of Baggendon, temporarily lost custody of her son and his land in Gloucestershire because the person from whom she'd purchased this child's custody had been falsely accused of being a rebel. But Alice was a very determined woman. She pursued her rights and successfully recovered her son and his lands. In relation to this, it's heartening to learn that a general recognition of the need to protect women and children in the aftermath of the First Barons' War is more broadly discernible in the surviving legal records from Henry III's reign, as good old C.T. Flower observed in his magisterial introduction to the Curia Regis Rolls, published by the Selden Society in 1983. Above all, said Flower, there was a growing tendency, particularly noticeable in the early years of Henry III, to regard the protection of the poor, the fatherless, and the widow as a duty of the court. The poor had their penalties remitted, minors were protected until they came of age, and in actions of dower, it was the widow who was protected by special rules and who was also given priority. Cumulatively, these experiences and attitudes helped to ensure that women and children's interests were preserved in the 1225 Magna Carta. So let's return then to the matters enshrined in the 1225 Magna Carta that directly address the needs, first of all, of widows. And here I acknowledge my debt to brilliant scholars like Janet Lowengard, Sue Sheridan Walker, and Scott Waugh, whose trailblazing research into widows, wardship, and the law in the 13th century has done so much to open up this field and did much to inspire my studies earlier in my career. In their detail, the 1225 Magna Carta's provisions for widows had a strong paternalistic air. Their purpose was to shield a potentially vulnerable group of women, women whose dead husbands were no longer there to protect them. Clause 7's purpose, as you can see here, was to ensure that on the death of her husband, the widow of a free tenant would receive her marriage portion, the portion of land that she brought to her husband at marriage, her inheritance, if she'd inherited land as an heiress, immediately and without any delay or difficulty. It also sought to guarantee that a widow would be able to freely take possession of her dower, the widow's share of her dead husband's lands, her marriage portion, and her inheritance, which she and her husband held on the day that her husband died. Under King John, of course, the widows of earls, barons, and knights had often been charged large sums of money for their lands. In addition to this, Clause 7 sought to alleviate some of the harsh financial uncertainties that faced the woman when she was newly bereaved. So it permitted her to reside within her dead husband's house for 40 days, during which time she was to receive her dower. Careful consideration was also now given to how a widow might provide for herself, hence the stipulation that a widow was also to have her reasonable estover or necessities from the common property that the widow and her husband's heir held. Clause 7 also defined the amount of land that a widow might hold in dower as a third of the property that her husband has held during his lifetime, unless he'd endowed her with less at the church door on the day of their marriage. But the end of Clause 7 also included the important provision, formerly Clause 8 of the 1215 Magna Carta, that no widow would be forced to remarry. In John's reign and earlier, it had been common for the widows of tenants-in-chief to offer the king sums of money so they might remain single, or if they wished to marry again, for permission to marry a candidate of their own choosing. So Magna Carta was important because it potentially removed the threat of forced remarriage and offered widows an extremely important safeguard in this regard. So what difference did Clause 7 make? Were its terms observed? So let's take Ella Longsby, Countess of Salisbury, as a test case. Ella's husband, William Longsby, died on the 7th of March, 1226, at the castle of Old Sarum in Wiltshire. On the 19th of March, 1226, just 12 days later, royal letters addressed to the sheriffs of Dorset, Somerset, Wiltshire, Berkshire and Surrey recorded that the king had taken the homage of our beloved Ella, Countess of Salisbury, for the lands in their bailiwicks, which belonged to her by inheritance from her father. So that was pretty good going, wasn't it? Yeah? Part of her inheritance, however, may have been overlooked, possibly due to the size of her estates or an administrative oversight. So other letters were then issued in mid-May, informing the Keeper of the Honour of Plympton in Devon that Ella also ought to receive her inheritance there as well. So far, so good. Significantly, though, there was also no sign that she paid a relief, an inheritance tax or other sum to enter her lands as a widow, which was good. Although admittedly, as a woman who was closely connected to the king and his court, Ella probably stood the best possible chance of ensuring that Magna Carta's terms were observed in her case. Frustratingly, though, I'm not entirely clear about what happened with her dower. There is, however, evidence, if we turn to look at another lady, that the 40-day rule for the handover of a widow's dower specified in Magna Carta did on occasion prove a little tricky to enforce in practice. This was true for countesses whose husbands held vast and scattered estates in different parts of England, Wales and Ireland. After all, it could be a mammoth task to survey the different lands, assess their value and identify their tenants, let alone allocate a surviving widow the third share to which she was entitled, as the experiences of Margaret, heiress to the barony of Bolingbroke and widow of John de Lacy, Earl of Lincoln, suggest. So we know that John de Lacy, Earl of Lincoln, Margaret's first husband, died on the 22nd of July, 1240. Margaret, John's widow, was then formally assigned her dower, third, on the 2nd of January, 1241, receiving domain properties valued at £315 per annum. So this was slightly longer than the 40 days envisaged in Magna Carta, presumably due to the size of Margaret's estates. Countess Margaret remarried and subsequently became entitled to a second dower allocation when her second husband died. And she sounds a bit like a black widow. She wasn't. She was just unfortunate. Margaret's second husband, Walter Marshall, Earl of Pembroke, died on the 24th of November, 1245. She then received a temporary dower allocation of English lands on the 26th of December that year, presumably to keep her happy. These included some wonderful Marshall family manors, though. Hampstead Marshall, the Marshall's ancestral family seat, and Caversham, which had been a favoured residence of the family. But poor old Margaret probably only finally received her final dower allocation in England and Wales in 1247, and she was only assigned her Irish dower in 1248. Her full dower entitlement, when it arrived, was probably worth the wait. It included estates worth more than £1,000 scattered throughout the realm. The size of her dower seems to have presented considerable challenges when it came to the swift allocation of her property, as did the existence of as many as 13 martial co-heirs to her late husband's properties. Poor old Walter was succeeded in very quick succession by a younger brother Anselm, who then died. And then the properties were all divided between the sisters of the family, 5 sisters and their surviving children. Margaret was still suing for compensation due to her from her delayed handover of her dower as late as 1259. She was quite a determined woman. The surviving records also indicate that under Henry III, most widows of free status were fairly successful in recovering their marriage portions, their dowers, and their inheritances. When they did encounter difficulties, they had recourse to litigation before the royal justices and were often able to recover their property in the king's courts. And this is apparent if we look at my own survey that I undertook many years ago of the fortunes of the widows of the knightly class in Lincolnshire. And also if we look at Janet Lowengard and Sue Sheridan's Walker's analysis of royal court records, which observe similar trends. If we look at extant heir records for different parts of England, there's evidence that those widows who did resort to litigation often stood quite good chances of success. So if we look, for instance, at the 1256 Shropshire heir, 13 out of 30 female plaintiffs who pursued their dower during that heir met with success, and this figure might be nudged upwards if we were able to trace the outcomes of those suits which were adjourned. I find that quite heartening. That may be because I'm looking forward to Christmas currently. So, did Clause 7 make a difference? There's also evidence elsewhere that Henry III and his officials were not negligent when it came to the matter of ensuring that widows had a roof over their heads and appropriate sustenance for the 40-day period while they were waiting for their dower. A nice case in point is this example from the Fine Rolls of Henry III. On the 8th of November 1242, Henry awarded Margaret, the widow of John Marshall, the manor of Greens Norton in Northamptonshire, expressly for her sustenance until the king has caused her rightful dower to be assigned for her. He also granted, though, Margaret the right to have her rightful sustenance without waste from the corn and other goods of the same manor for 40 days after her aforesaid husband died. Furthermore, as a result of Clause 7's provisions that no widow should be forced to remarry so long as she wished to live without a husband, no longer did widows feel the need to purchase regularly from the Crown the privilege of remaining single or marrying a man of their own choosing. During Henry III's 56-year reign, just 44 widows in the whole of England offered the king money for the freedom to choose their own husbands, and they paid on average £58 each, which was much less than earlier widows had been accustomed to pay under King John. And this is thanks to Susanna Annesley's work on these figures. After Magna Carta, then, Henry III was only able to withhold his approval for a widow's marriage. He was no longer able to force her to marry by seizing her goods and property. Instead, distraint tended to be replaced by persuasion when the king wanted a widow to marry a man whom he favoured. But what then of those clauses in the 1225 Magna Carta that touched upon the treatment of underage heirs and heiresses? Let's look briefly then at Clause 6. Heirs shall be married without disparagement, i.e. they should not be married to a person who was not equivalent to them in social rank or status. They should not be married to a social unequal. There are signs here that Henry III's government officers, in their intentions at least, were not entirely negligent here too. On or around the 5th of April 1242, for example, Master Peter, the Archdeacon of Shrewsbury, was awarded custody of the lands and heirs of Alan of Mauvansin in Shropshire, together with their marriages during their minorities, in return for a payment of 25 marks. Master Peter then received royal letters which awarded him the custody and which specified quite carefully that the aforesaid heirs are to be married without disparagement. Even so, though fears of disparagement which it was believed could pollute bloodlines and lead to the birth of inferior children, persisted in Henry III's reign, due at least in part to this king's preferment of foreigners at his court and his generosity to them. The foreigners in question were, of course, his wife, Eleanor of Provence's kin, and the king's own half-siblings, the Lusignans, the children of his mother Isabella of Angoulême's second marriage, and their many associates. The St. Albans chronicler Matthew Paris, for example, famously commented upon how the marriages of two provincial girls to two young nobles, namely Edmund, Earl of Lincoln, and Richard de Burgh, caused considerable murmur and indignation to reverberate throughout the kingdom. One of these nobles, Edmund de Lacy, was the son of our Margaret, whom we've already met. He was heir to the earldom of Lincoln. He married Alice of Saluzzo, a cousin of the Queen, but Alice was, to be fair, the daughter of an aristocrat, the Marquis of Saluzzo, so there are few grounds really for regarding this union as a mesalliance. Additionally, in 1247, William of Valance's marriage to Joan de Montchesney, one of the co-heirs of the vast earldom of Pembroke, similarly provoked contemporary comment. Valance was Henry III's Lusignan half-brother. Sadly, though, xenophobia underpinned contemporary criticism of such marriages amidst the struggle for patronage and the factionalism of Henry III's court. In 1258, the petitions of the barons, drafted at the time of the emergence of a baronial reform movement in England, demanded that women in the king's gift shall not be married in such a way that is to disparage them, that is, to men who are not true-born Englishmen. But what of those clauses protecting the properties of underage heirs? Well, clauses 4 and 5 have quite a protective tone towards them. Clause 4 laid down that the guardian of the land of an heir who's underage shall take from the land of the heir no more than reasonable revenues, and so on, without destruction and waste. Clause 5 laid down that so long as he has the wardship of the land, the guardian shall keep in repair the houses, parks, preserves, ponds, mills, and other things pertaining to the land out of the revenues from it, and he shall restore to the heir, when he comes of age, his land fully stocked with ploughs and other things. When it came to the matter of protecting the persons and properties of children in wardship, sadly the 1225 Magna Carta's enforcement might have had more modest gains. After all, the trouble with Magna Carta is that it did nothing to prohibit the trade in wardships, their sale or granting away by the king or another lord, which remained a feature of royal government throughout Henry III's reign. Henry III and those closest to him continued to regard and treat wardships as a valuable source of patronage and revenue. Interestingly, actions of waste, though, were brought by disappointed heirs against their guardians before the royal justices, although sometimes with mixed success. And we also know of writs purchased by heirs and others who wished to sue the keepers of lands that had been placed in their care during a minority. In June 1242, for example, Simon de Hill purchased a writ to initiate legal proceedings before the Archbishop of York against Matilda de Valois, who he alleged had made waste and destruction of his inheritance in Rudham against the king's prohibition. Some comital heirs, like this chap, John de Warenne, also suffered at the hands of their guardians. Although, as my student Katie Delaney has shown, the Sussex and Surrey lands of John de Warenne, the young heir to the earldom of Surrey, were awarded in September 1241 to Peter of Savoy, the Queen's uncle. Savoy proved to be an acquisitive custodian, who, according to local jurors reporting on his activities 2 years later, had wasted John's woods. This, as well as Savoy's ultimate retention of Warenne's lands for 4 years beyond John's legal age of majority, he kept them till John was 25, goes a significant way, Katie suggested, to explaining Warenne's later enmity and political opposition to Savoy in adulthood. This all helps to explain why some families actually acted on their own initiatives to secure the futures of their children and the futures of their estates. So when Edmund de Lacy died in 1258, his wife Alice of Saluzzo and his grandmother Margaret, his mother Margaret, acted together. The two women actually made a covenant with the king and secured the wardship of his lands, of the lands of Edmund's son and heir Henry. So they divided them up between them, which I think is rather a touching image of familial, maternal, and wifely cooperation. Wardships rumbled on as a political issue throughout Henry III's reign then, and were discussed as part of the baronial programme for the reform of the realm in the 1250s. The provisions of Oxford lay down, for example, that the Royal Chancellor was to swear that he wouldn't authorise with the Great Seal any grant of a greater wardship without the advice of the Great Council. It should also be noted, though, that female lords were just as active as male lords in pursuing rights to wardships over their tenants' heirs in the courts, and so had a vested interest, perhaps, in preserving the status quo unless they were personally impacted as mothers. Finally, then, let us look at the two clauses that concerned inheritance taxes, reliefs. Clause 2, of course, limited the rate for baronial reliefs to £100 and the rate for knightly reliefs to 100 shillings at the most for a whole knight's fee. Clause 3 also set down that a ward shall have his inheritance when he comes of age, that is 21 years, without paying any relief. From the beginning of Henry III's reign, the rate for baronial reliefs was indeed usually fixed at £100, as David Carpenter has shown us. No longer were the heirs of earls and barons charged large arbitrary sums of money for their inheritances, and this was a substantial and good concession by the Crown. But King Henry's government, even after the 1225 reissue, stopped short of cancelling all outstanding debts to the Crown that had been incurred as reliefs under King John. So I always feel somewhat saddened by the circumstances of Nicholas de Stuteville's heirs in the north. They were still struggling, we know, in the 1250s to repay the debts owing from a large relief of £6,666 that had been imposed on Nicholas by King John for the baronies of Cottingham and Knaresborough in Yorkshire. Under Henry III, though, wards were also seemingly able to fare a bit better insofar as their exemption from reliefs was concerned. So by way of conclusion then, the 1225 Magna Carta and its earlier reissues were the product of a political society that recognised the need to protect women, children and families. At the end of the day, though, did it make any meaningful difference to the lives of its intended beneficiaries? The answer, certainly from the point of view of reliefs, widows' marriages and property rights, is that yes, for the most part, Magna Carta's terms were observed in Henry's reign. Note that qualifying statement. We must also acknowledge, though, that altogether the terms of Clause 7 were generally observed after 1225, but even in spite of this, widows' property rights remain such key issues that they continue to be legislated on in later decades. In the Statute of Merton of 1236, for example, we find measures to prevent widows from being deprived of their dower and measures permitting widows to receive damages for the time between a husband's death and the time that they took to gain possession of their dower. Wardships remained important resources for the king, as well as for lords, male and female, who enjoyed similar rights over underage heirs and their tenants. So in the realm of wardships, Magna Carta's provisions were more limited. Ultimately, though, and I think rather sadly in human terms, Magna Carta stopped short of making it any easier for mothers to purchase the custodies of their children and their lands, and to protect them from the activities of negligent, selfish or greedy guardians. Not only was there an overall decline in the practice of granting wardships to widows, but some of those ladies who did manage to gain possession of their offspring had to go to considerable lengths to do so. Isabella, Countess of Oxford, for example, agreed to pay King Henry III the monumental sum of £2,228 for the wardship of her young son and his estates. As an insurance policy against Isabella defaulting on this sum, she was required to find no fewer than 75 individuals, men and women, who acted as her pledges in 11 English counties. She must have loved her son a great deal. The end.
Thank you, Louise, for such wonderfully illuminating talk. I learned a lot. I hope everyone else did here as well, and for pointing out to us the benefits and weaknesses of the 1225 Magna Carta, especially for women and children, and We do have a bit of time for questions. I'm sure Louise happy to answer some. We have a roving mic, so Molly, do you want to at the back?
Thank you very much. A wonderful paper. The sources for the 13th century, of course, are very radically different from those of the 12th century. And I'm wondering whether anything could be said about the position of widows and wards in the 12th century. I ask because it is possible to see that King John's activities are in fact breaking a tradition of what we might call decency towards widows and lords and wards, so that they're getting back to a status quo that they knew earlier.
Well, for the 12th century, we're blessed because we have the pipe rolls, which are wonderful. And you can join the Pipe Roll Society for £25 a year. We're still going, we're very good value. And those record royal revenues, and they include offerings made by widows for the right to remain single, for the right to control their properties, and all sorts of other business relating to widows and indeed children. And looking back, we can see actually that they were exploited, if we put that interpretation on it, in the 12th century as well. There's a fine example from the earliest full pipe roll that survives from Henry I's reign, actually, of Lucy, Countess of Chester, who outlived 3 husbands and was heiress to Bolingbroke in Lincolnshire. And she paid a considerable sum of money so that she would not have to marry again in the next 5 years. And I always have a tremendous amount of sympathy for her, and also so she could control her estates in her own right. She was aided by 2 very capable adult sons, though, who went on to become great leaders in Lincolnshire and nationally, William de Ramar and an Earl of Chester. If we look back, if we look to Henry II's reign and Richard's reign, it's a similar impression of exploitation that we find under John. But thanks to the work of people like Nick Barrett, who went through all the pipe rolls for John's reign, we know that John really sort of racked up the level of intensity for his exploitation of what in traditional scholarship would be called feudal assets, and ran everything at a greater pitch of intensity because he was desperate, really, to raise money for the recovery of Normandy in that period up to 1214, when they hoped that a successful campaign might recover his lost continental possessions. There were some widows who certainly had a terrible time under Richard I, his brother. Yeah, so actually the 12th century is fairly bleak as well, but John, I think, definitely made things worse. And then in Henry III's reign, we do get these really decent concessions.
Any other questions?
Thank you very much for that really interesting talk. Do we know who was championing the changes from 1215 to 1225?
I think it must have come out of the rebel barons largely. I think there was a sympathy within the royal courts anyway. You can see it building up through the Curia Regis rolls. And it's a pity we don't have Curia Regis rolls from before, really, in any detail from before John's reign, way back into the 12th century, surviving. There are some for Richard's reign that have been published. But I think it's really the rebel barons. I think because widows have such a key share of the lands, because women can inherit vast estates potentially, it is in the interests of families to preserve their rights and property. Otherwise, the great family inheritance could just be denuded. So I think, and I think the experiences of different families, like the de Lacys, they had a tough time under John, really helped to sort of drive this sort of effort forwards at a baronial level. And of course, because they needed a broader class base and support base, the interests of the knightly class particularly were brought in. And yeah, so I think it's a collective effort. And it just shows you how integrated women are into families, which is rather nice.
Thank you. Presumably a lot of the women, even if they're aristocratic, when they're suing for their rights are going to need supporters of one kind or another. I mean, somebody like Margaret de Vesey, who has just been on the losing side, her husband has just been on the losing side in the Civil War. Do we know anything about the supporters, the people who would have backed her up? I mean, would she have been able to draw on the sort of backing that her late husband had had when she was suing on these sort of occasions, or later widows as well?
I think she would have been able to draw on sort of local support networks. But the question is, if you're on the wrong side, is how effective there are. If you were a wife, perhaps, say if we look at the second Baron's War of Henry III's reign, who had perhaps come from a royalist family, there's a Bassett wife, isn't there, Aline Bassett, who marries Hugh Despenser, who's Constable of the Tower of London, I think that's right. After the Civil War, she does reasonably well because actually her father steps in to help her. So I think where there were marriages across political divides, those might have come into play. Where I think there were ties of neighbourhood, I suspect those would have come into play. And of course, these women who were suing could call upon the services of attorneys. And if they chose wisely in their attorney, I think that would have helped their cases tremendously. So, you know, knowledgeable tenants and knowledgeable men in the law. Yeah. Yeah, I think so. I think I think there would have been a tremendous amount of sympathy among former rebels for one another, but they would have also been hedging their bets, wouldn't they? To make sure they were seen to be now loyal to the new status quo. So I think I think it's all about people's relationships, really. And then that's expressed through the records of the law.
I think we have time for just a couple more, if there are any.
Were the provisions of Magna Carta 25 made widely known so that the women would know what they could claim, and particularly for people slightly lower down the social scale?
Yes, they were. So they were publicised in the county courts. It was literally read out in the county courts. We know that by the 1250s it was circulating, certainly, and copies of it were circulating in French, I think in English, Henry will know, and in Latin. That might have been later, but certainly in French and Latin. And I think people would have attended the county courts as litigants, their neighbours would have attended, the knights who were serving on local juries would have attended, and they would have brought that information home to their wives if they weren't present in the court themselves. So I think it was incredibly well known. And when I was looking many years ago at some air rolls for Lincolnshire in the National Archives for the 1280s, there were some lovely examples of cases where people sort of, a couple of examples, I think, where people came into court and they quoted Magna Carta and they didn't quite get it right, and they were fairly lowly in status, but they sort of knew its principles, which is a jolly good sign. And John Maddicott's published on Magna Carta in the local community. I do think its contents came to be quite widely sort of understood, certainly among the property classes. And you can imagine people talking about it. Yeah.
I think amongst the peasants too, from what I've looked at, from their maybe misunderstandings as well. One more.
Thank you for a very interesting talk. Can I ask, do we have any extant wills from women directly affected by the provisions?
Yeah, so there's a nice example actually, which is published in one of the Registrum Antiquismum volumes from the Cathedral Church of Lincoln. And I think it also bizarrely survives in Anne Clifford's papers as a later copy. But there's a Clifford woman who, in the 1220s, with the permission of Walter, her husband, is allowed to make a will. And it sets out all her bequests. They control a castle in Lincoln that's held from the Bishop of Lincoln. All her bequests, she leaves sort of lovely things like rings to her daughters and different items to her sons, bequests to local religious houses. And that's just one of my favourite examples, actually. It's really nice. Wills don't tend to survive that early in vast, vast numbers in this brave sort of post-conquest world. But when they do survive, in sort of growing numbers from the later 13th century onwards, you do find examples of husbands giving their wives permission.
Thank you. And I think perhaps our present-day Chancellor of the Exchequer should read Magna Carta 1225 before she embarks on inheritance taxes, etc. But enough of politics. Can we thank Louise in a time-honoured tradition? And I give notice that the next meeting will be on Thursday, the 27th of November, where we will hear a paper, Robust Methodologies in Skyscape Archaeology, Case Studies from Malta and Peru by Fabio Silva and Professor Clive Ruggles, FSA. The meeting stands adjourned and a reception will follow. Thank you all.